What made this moment explosive wasn't a dramatic order signed by Donald Trump or a late-night press conference from City Hall. It was silence from the bench. Across multiple federal cases over the past several years, judges have increasingly declined to issue emergency injunctions that cities once relied on to block federal action in its tracks. That shift matters because injunctions are the single most powerful tool cities have used to slow or stop presidential authority. During Trump's first term, courts repeatedly intervened at early stages, most notably in 2017 when several judges halted attempts to condition federal grants on immigration cooperation. Those rulings created a powerful expectation. When cities sued, courts would pause enforcement while the fight played out. But that expectation no longer holds. Federal judges now emphasize that disagreement with executive policy does not equal irreparable harm, and without that finding, courts step aside. When that happens, federal authority continues uninterrupted, and cities lose the legal shield they once counted on. The legal standard behind this shift is not new, but its application has become far stricter. Under Supreme Court precedent, particularly Winter v. Natural Resources Defense Council, a party seeking an injunction must show a likelihood of success on the merits, a likelihood of irreparable harm without relief, that the balance of equities tipped in its favor, and that an injunction serves the public interest. In recent years, federal judges have focused intensely on the irreparable harm requirement. Financial uncertainty, administrative disruption, and political conflict, once persuasive arguments for cities, are now often deemed insufficient. Judges have repeatedly stated that courts are not meant to act as preemptive supervisors of the executive branch. That doctrine has had real consequences. When cities ask judges to block federal enforcement tied to immigration, grants, or regulatory compliance, they increasingly hear the same response: the court will not intervene at this stage. For Trump, this environment is uniquely advantageous. His approach to federal power has consistently relied on enforcing statutes already passed by Congress rather than pushing novel legislation. Immigration Enforcement Authority, conditions attached to federal grants, and regulatory oversight are all grounded in existing law. That means Trump does not need to win sweeping court victories to advance his agenda. He only needs courts to refrain from stopping him. When a judge refuses to issue an injunction, there is no headline declaring Trump the winner, but the effect is immediate. Federal agencies continue enforcing rules, funding conditions remain in place. Cities are forced to decide whether to comply, risk penalties, or litigate without protection while enforcement moves forward. The stakes for cities are enormous. Federal funding represents a significant share of municipal budgets, particularly in transportation, housing, public safety, and social services. According to Congressional Budget Office data, state and local governments collectively receive hundreds of billions of dollars annually through federal grants and transfers. Even the possibility of disruption can trigger emergency budget reviews, hiring freezes, and delayed contracts. City attorneys often advise caution the moment judicial relief is denied, warning departments that noncompliance could expose them to enforcement actions or future clawbacks. This pressure does not require a single dollar to be immediately cut. Uncertainty alone reshapes behavior. What makes this moment especially dangerous is how quietly it unfolds. There is no single ruling that announces cities have lost. Instead, protection erodes case by case, motion by motion. Judges emphasize restraint, orders are narrow, relief is denied without prejudice, but the cumulative effect is unmistakable. The courts are signaling that they will no longer automatically shield cities from the executive branch during political conflict. That leaves local governments facing federal power largely on their own. This is why the refusal to intervene is more consequential than any individual Trump policy. Courts stepping aside changes the balance of power itself. It tells cities that legal battles may still be fought, but not on the timeline they need to prevent damage. Enforcement can proceed first. Harm can occur first. Relief, if it comes at all, may come later. And once that precedent settles in, it doesn't matter who occupies the White House. The shield cities once relied on is no longer guaranteed, and the consequences of that reality are only beginning to surface. Federal courts have become one of the biggest, least talked about obstacles shaping how cities deal with homelessness and housing, and this pressure intensified during and after Donald Trump's presidency. Long before today's mayors started declaring emergencies, judges were already warning city leaders that aggressive crackdowns on encampments could violate constitutional protections. The most influential moment came in 2018, when the Ninth Circuit Court of Appeals ruled in Martin v. City of Boise that cities cannot criminally punish people for sleeping outside if no adequate shelter is available. That ruling did not create homelessness, but it permanently changed what cities are legally allowed to do. By the time Trump entered office, that decision was already binding across much of the western United States, including California, Oregon, and Washington, placing mayors in an impossible legal bind: clear encampments and risk federal lawsuits, or leave tents in place and face public backlash. During Trump's term, the Department of Justice did not reverse this ruling. Instead, it quietly reinforced limits on local enforcement by intervening in cases where cities attempted mass sweeps without shelter guarantees. Federal judges repeatedly issued warnings that homelessness could not be policed away. These rulings forced cities to spend millions defending lawsuits rather than building housing. San Francisco, Los Angeles, and Seattle all faced legal challenges after residents and advocacy groups sued over encampment removals. In several cases, courts ordered cities to pause cleanups unless they could prove sufficient shelter space was available. These court-ordered pauses became political landmines for mayors, who were then accused of doing nothing, even when their hands were legally tied. At the same time, Trump's administration pursued a contradictory housing strategy that further strained cities. While publicly criticizing sanctuary cities and urban leaders, the administration proposed repeated cuts to federal housing assistance, including reductions to HUD programs that fund affordable housing construction and rental support. Congress blocked many of the deepest cuts, but uncertainty alone slowed housing development. Cities planning multi-year housing projects rely on predictable federal funding streams. When those streams appear unstable, projects stall, financing collapses, and timelines stretch. By the time funding clarity returned, construction costs had already surged, leaving cities with fewer units than originally planned. Mayors were also caught in legal crossfire between state mandates and federal oversight. California, for example, strengthened housing accountability, laws requiring cities to approve more housing or face penalties. Yet federal court rulings restricted enforcement actions against unsheltered populations during the very period when housing supply was falling behind demand. Judges made it clear that cities could not meet housing quotas by simply pushing homeless residents out of sight. Several courts explicitly warned municipalities that relocation without housing access could trigger civil rights violations. These warnings were not theoretical. Cities that ignored them faced injunctions, legal fees, and court-monitored compliance orders that limited local authority even further. Trump himself repeatedly threatened federal intervention in cities he labeled as out of control, including suggesting that federal agencies step in to manage homelessness. However, no sweeping federal takeover ever materialized. Instead, cities were left navigating a fragmented legal landscape where federal courts limited enforcement. Federal funding remained uncertain, and political pressure intensified. Mayors publicly demanded more authority, but behind closed doors, many acknowledged that court oversight had become the decisive force shaping policy. Every encampment sweep, shelter expansion, or emergency declaration had to be reviewed through a legal lens, not just a political one. This legal chokehold explains why homelessness policy often looks slow, inconsistent, or contradictory. It is not simply bureaucratic failure. It is the result of years of court rulings, federal funding instability during the Trump era, and ongoing judicial warnings that continue to dictate what cities can and cannot do. The crisis is visible on the streets, but the real battlefield sits inside courtrooms, where judges, not mayors, ultimately decide how far cities are allowed to go. The moment courts decide not to intervene, the consequences hit cities and residents immediately, and often in ways that feel unavoidable. Federal authority moves forward without pause, and city leaders are left scrambling to manage the fallout. For mayors, the legal limits imposed by rulings like Martin v. City of Boys and subsequent injunction denials mean they cannot forcibly clear encampments without sufficient shelter. At the same time, federal grant conditions remain in effect, creating a high-stakes environment where a single misstep could risk billions in funding for essential city services. In practical terms, this uncertainty ripples through schools, hospitals, and public agencies. San Francisco, for instance, relies on federal funding to operate housing programs, support homeless shelters, and maintain critical health services. Even a temporary freeze on grant money forces city departments to delay programs, halt new hires, and postpone construction projects, directly affecting thousands of residents who depend on these services every day. The human cost is immediate and measurable. Homeless families see shelter beds disappear, forcing children to sleep in cars or on sidewalks. Public hospitals delay elective surgeries or limit outpatient services because federal reimbursements are uncertain. Nurses and social workers face increased workloads, often without additional staff, while municipal budgets are frozen in anticipation of possible funding penalties. Small business owners in affected neighborhoods report declines in customer traffic and revenue, as uncertainty over city policies creates an unstable environment for commerce. Economists note that local economies are particularly sensitive to delays in federal aid. Even short-term disruptions can ripple outward, slowing job creation and delaying housing construction, which in turn exacerbates the very homelessness problem city leaders are trying to solve. Statistics illustrate the scale of the impact. According to HUD and Census Bureau data, over 1.5 million people live in federally assisted housing programs in the U.S., with tens of thousands in California, cities directly dependent on temporary funding allocations for emergency shelters and supportive services. Any delay or legal challenge to these programs jeopardizes their stability. Public schools also feel the strain. City budgets tied to federal allocations support after-school programs, nutrition services, and mental health counselors. When grants are frozen or threatened, these programs shrink, leaving children without crucial educational and social resources. Perhaps the most visible consequence is the widening gap between political authority and street-level reality. Mayors are expected to deliver results, yet court rulings limit their tools. Encampments grow, and citizens see no immediate solution. Tensions rise between local officials, residents, and advocacy groups, each blaming the other for the impasse. Media coverage amplifies the drama, often showing images of tents lining city streets, while simultaneously highlighting court rulings that prevent forced removal. The legal framework, once protective, now constrains action, turning every decision into a delicate balancing act between compliance, public perception, and human need. And yet, the officials responsible for navigating this legal labyrinth remain in power. No court ruling holds them accountable for public frustration, only for legal compliance. The result is a city in freeze mode. Emergency funding delayed, housing projects postponed, shelters stretched beyond capacity, and frontline workers forced to operate under intense pressure. The invisible machinery of the law drives visible consequences on the streets, leaving citizens to experience the full impact of systemic tension between federal authority, judicial restraint, and local governance. In short, the human and economic fallout is immediate, widespread, and deeply personal. From families relying on shelters to small business owners navigating frozen city budgets, the refusal of courts to act early creates cascading effects. Residents live the consequences every day, while leadership struggles to balance legal constraints with public demand. The courts may not be issuing orders, but their decisions, or refusals, reshape life in every corner of these cities. When cities face this level of crisis, the question everyone asks is simple: who allowed it to happen? The answer is complicated, but the responsibility falls squarely on multiple levels of leadership, and in this case, Trump's administration plays a central role. During his presidency, Trump repeatedly used federal authority to pressure cities, particularly those he considered sanctuary or progressive strongholds like San Francisco, Los Angeles, and New York. He threatened to withhold federal funding tied to public safety, housing, and transportation programs if city officials did not comply with federal enforcement priorities. These were not empty threats. Agencies such as HUD and the Department of Justice issued warnings that grants could be delayed or cut if compliance did not meet federal standards. In other words, cities were caught between a rock and a hard place: enforce federal directives and risk court challenges, or follow court guidance and risk losing essential funding. Mayors found themselves publicly criticized by Trump while simultaneously being legally constrained. San Francisco Mayor London Breed, for example, faced multiple legal warnings during Trump's term regarding encampment sweeps. Courts reminded her administration that clearing tents without adequate shelter violated federal constitutional protections, while the Trump administration signaled that funding could be at risk if cities failed to enforce federal immigration and safety directives. Across California, other mayors, including Todd Gloria in San Diego and Matt Mahan in San Jose, faced similar pressure, balancing federal threats, local legal limits, and public outrage over visible homelessness. The tension created a situation where no single leader could satisfy every requirement or expectation, leaving cities politically exposed while legally restricted. The controversy deepens when examining legislative and budgetary decisions. State lawmakers often mandated increased housing production or funding transparency, yet federal oversight limited how local governments could act on homelessness and public safety. Trump's legal and administrative strategies did not create the laws, but his administration's enforcement posture amplified their impact. Cities were forced to make impossible choices, comply with judicial rulings and risk public backlash, or prioritize immediate enforcement and face lawsuits or clawbacks on federal aid. Every action or inaction was scrutinized, politicized, and amplified in national media coverage. Judicial restraint played a critical role as well. Courts repeatedly refused emergency injunctions that cities hoped would block federal threats. Judges emphasized that federal authority should continue unless there is clear constitutional violation or imminent irreparable harm. This meant that cities had little legal recourse, leaving mayors accountable in the public eye, but constrained by law and practice. Even when warnings were issued, compliance with legal limits often appeared as failure to constituents, creating a political and administrative paradox that cities could not easily navigate. The fallout highlights the disconnect between authority and capability. Trump used executive power to push cities toward compliance while courts limited local enforcement tools. State and local officials were left to respond to a system they could not control. Audits, reports, and internal investigations revealed that many municipal departments were unprepared for the rapid escalation of federal pressure, despite repeated warnings from legal advisors. Resources intended for housing and public services were redirected toward legal defenses, delaying essential programs for those who needed them most. In the end, the responsibility is shared. Trump's administration leveraged federal authority to pressure cities. Courts enforced legal limits that constrained mayors, and state and local leaders struggled to implement solutions within these constraints. The result is a perfect storm: cities unable to act decisively, residents experiencing the fallout firsthand, and political leaders publicly blamed for circumstances that were largely dictated by legal and federal frameworks. Every decision carries weight, and every inaction has consequences. The crucial point is this: while leadership may appear passive on the streets, the true drivers of accountability are often legal and federal pressures, not simply municipal failure. The mayors remain in power, but their ability to govern is constantly checked by court rulings and federal enforcement strategies, leaving citizens to face the full brunt of the systemic gridlock. The consequences of this legal and political standoff are only beginning to reveal themselves, and the outlook is far from optimistic. Cities across the country are now operating under unprecedented pressure, where federal authority continues unchallenged, courts have stepped back, and mayors are left with limited tools to respond. The long-term implications for residents, services, and the local economy are staggering. In California alone, federal grants support thousands of essential programs: housing subsidies for low-income families, public health initiatives, after-school programs, and emergency services. When courts refuse to block federal enforcement actions, these programs face delays, reduced funding, or complete suspension. According to HUD latest data, nearly 1.2 million Californians depend on federal housing assistance. Even a short-term disruption leaves tens of thousands without guaranteed shelter, forcing families into crowded temporary accommodations or onto city streets, heightening the risk of illness, accidents, and social instability. The healthcare system is under similar strain. Public hospitals and community clinics rely heavily on federal reimbursements for operations. Funding freezes or legal uncertainties can delay equipment purchases, staffing, and service expansion. Already, hospitals in cities like Los Angeles and San Francisco report longer wait times, postponed procedures, and overworked staff, all compounded by the legal limbo surrounding enforcement policies. Nurses, social workers, and public health employees face daily challenges navigating unpredictable city directives while attempting to meet growing demand. When essential services falter, it is the residents on the ground, children, seniors, low-income families, who bear the immediate burden. The economic impact extends far beyond the streets. Small businesses, reliant on predictable municipal services and community stability, are struggling. Delays in city funding and program support create uncertainty in local labor markets, slow housing development projects, and discourage new investments. According to the National League of Cities, disruptions in federal funding and city operations can reduce employment growth by up to 10% in affected sectors, particularly construction, social services, and healthcare. This compounds the crisis. Fewer jobs mean fewer resources for residents, increasing demand for city services at the same time that legal constraints prevent effective responses. Worse, the social consequences are visible and growing. Homeless encampments remain in public spaces longer than ever, sparking community frustration, political outrage, and media attention. Families living in shelters or temporary accommodations report increased stress, reduced access to schooling, and difficulties securing stable employment. Parents struggle to find childcare, students face interruptions to learning, and community organizations must stretch limited resources to cover growing needs. The combination of legal limitations and federal enforcement has created a scenario where city leaders are trapped. Visible action risks lawsuits, while inaction invites public condemnation. Looking ahead, the crisis is poised to worsen. Without changes in federal policy, court intervention, or new emergency funding, the risk of service collapse increases. Education systems may face cuts to after-school and nutrition programs. Healthcare providers could delay non-emergency care. Housing projects may stall indefinitely. Income inequality could widen, with the most vulnerable populations suffering disproportionately. In the absence of decisive action, cities may reach a tipping point where social, economic, and public health consequences intersect, creating emergencies that are far more severe than today's. Headlines suggest the critical question for residents and leaders alike is not whether the situation can deteriorate, it already has, but how long the public will tolerate the strain. Legal and political frameworks have left cities exposed, and Trump's federal strategy, coupled with judicial restraint, has shifted the balance of power decisively toward federal authority. For mayors and city officials, the challenge is immense. They must navigate federal pressures, court limitations, and public expectation simultaneously. For citizens, the reality is immediate. Streets, schools, hospitals, and neighborhoods are all affected. Ultimately, the situation is a stark warning. The protections that once allowed cities to act freely are eroding. The decisions made or avoided today will shape the quality of life for millions in the months and years ahead. The question isn't whether the fallout will continue, it's how much more disruption communities will endure before meaningful solutions emerge.